Yes, is Miss Burton in here? Karen Burton, if you'll make your way to the center podium. Awesome, yes, just like perfect, thanks. Mr. Green, are you ready on Miss Burton?
I'm ready, Judge.
All right, this is cause number CR 2324. State versus Karen Sue Burton. We're set for pretrial. Can you see your client, Mr. Green? She's in that center.
Get the podium.
Yes.
Yes, sir.
All right. Go ahead. Do we have any contested pretrials?
Judge, I do have a motion to suppress that I filed that I need to get a date for a contested hearing.
All right. Probably do not want that to be next week, right?
I do not. I'm not even sure I'm available next week. It's crazy over here right now.
What about April 29th? That would be the evidentiary date in April.
Is that in the morning or afternoon?
We begin everything. We begin jail cases and non-jail cases all at 9 on those days. So we could set it in the afternoon if we need to.
Let me make sure. Afternoon would be better if we could, Judge.
All right, Ms. Burton, I'm going to order you back before the court for evidentiary hearing on April 29th at 1:30 p.m. I need some more notice forms, if you don't mind.
That's all my business, Your Honor. May I be excused?
Yes.
Thank you.
Mhm. All right, Ms. Burton, I'm gonna have the bailiff bring this to you. You're gonna sign right there on the X, and then we're gonna give you a copy of that. It just says that you're gonna be back on the 29th. Mr. Calabria? All right, this is cause number CR 2173 and 174. State versus Wendy Staley Ledoux. All right, Ms. Ledoux, if you'll raise your right hand, I'm going to place you under oath. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you may put your hand down. Make sure you speak up loudly and clearly so my court reporter can take down everything you say, okay? All right, Ms. Ledoux, are you a United States citizen? Do you read, write, and speak English? Have you ever been diagnosed with any type of mental condition?
No.
In this case, you're represented by your attorney, Mr. Mark Calabria. Are you pleased with his representation of you? Do you feel like you've had enough time to discuss your case with him and have all your legal questions answered?
I do.
Mr. Calabria, do you believe your client to be competent today?
I do, Your Honor.
And you have explained to her legal and constitutional rights, as well as the advantages and disadvantages of a deferred adjudication plea?
I have, Your Honor.
Ms. Ledoux, you are charged by indictment with 2 third-degree felony offenses of false statement to obtain property or credit greater than or equal to $30,000, but less than $150,000. Each one of these charges, both being third-degree felonies, carry the same range of punishment. that is confinement in the Texas Department of Criminal Justice Institutional Division for not less than 2 years or more than 10 years, and fines not to exceed $10,000 in each case. Do you understand that? Understanding that if the court approves this plea agreement today, wherein the state's recommending that you be placed on deferred community supervision, if the court approves the agreement and later you violate the terms and conditions of the court could revoke your community supervision and could assess your punishment anywhere up to 10 years confinement in the Texas Department of Criminal Justice. You understand that? Court could also impose fines up to $10,000 in each case. You understand that as well? All right, understanding that, Ms. Ledoux, how do you plead to these offenses? Is that part of the plea agreement? All right, so no contest or nolo contendere. Do you understand that pleading no contest in a criminal court has the same legal effect as pleading guilty? Okay. All right, then has anyone threatened you, forced you, or pressured you to make you feel like you need to plead no contest to these charges? No. All right. And Mr. Calabria, is there any objection to State's Exhibit 1 in each case?
No, sir.
All right, then the stipulation of evidence is admitted in each case respectively, and the court takes judicial notice of the defendant's no contest plea in each charge. Is there anything further from the state?
Yes, Your Honor, the state is in compliance with victim notification, and while we don't have a victim impact statement, victims in each of these cases have been highly involved in this process. As part of the plea agreement, Ms. Ledoux is going to pay a significant amount of restitution today. In addition, they have provided through Mr. Calabria the victims have filed a claim against the business's insurance to recuperate the rest of the restitution. So when you read the facts of this case, you'll see the amount alleged is much higher than the restitution today, and that's the reason for the offset, Your Honor.
And so there's no additional restitution to the insurance company?
I think that matters unresolved, Your Honor, between the claimants and insurance companies.
They're processing that separately. The restitution moving forward today is the payments that the victims have made towards the mortgage in the meantime while this is being resolved. Their out-of-pocket payments is what we agreed to reimburse through restitution.
Okay. Thank you, Ms. Heisel. Anything else from the defense?
No, Your Honor, we rest.
Ms. Ledoux, your signature as it appears throughout these documents, is it your true and correct signature? All right, based on the court's review of the evidence, I find that there is sufficient evidence to convict Ms. Ledoux of these offenses. The court will follow the plea agreement between the state and the defendant, and cause number CR 20173. The court hereby defers the finding of guilt, places Ms. Ledoux on 5 years community supervision, assesses restitution in the amount of $3,234.88, orders her to pay court costs of $290 and a $15 reimbursement fee. And cause number CR 20174, court defers the finding of guilt in that case and assesses, well, and places Ms. Ledoux on 5 years community supervision as well. assesses restitution at the amount of $3,767.22. Court orders her to pay court costs of $290 and reimbursement fees of $15. State, do me a favor, the written plea admonishments are not filled out at all. No cause number, no defendant, no punishment range, no plea agreement. So everybody signed it, but
I believe that'll be the case on both.
Perhaps that's my mistake, Your Honor.
Mr. Lloyd, you're on deck. You'll be on deck, just to let you know. Then Mr. Steele with Mr. Miss Marshall after that, and then if Mr. White is. Mr. White.
Judge, I just for a reason on the case. Like, we'll wait till.
Give me just a moment. Mr. Adams, will you do me a favor? Will you see if Mr. Nolan White is in the hallway? If he is, just let him know that his client is present online now and we can do his last case. Mr. Lloyd, I'm gonna allow Mr. White to slide in right after Mr. Clavria. He's got one client left. He's on Zoom and shouldn't be, but just a minute or two. All right, Ms. Ledoux. Court hereby remands you to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of your sentence. I'm gonna have you step forward to be fingerprinted with the bailiff. After that time, just step over here with Ms. Burns and she'll give you further directions.
Thank you, Your Honor, being told this. I had it.
Appreciate your patience.
I'll take you on a spring break.
Enjoy. All right, Mr. White, if you'll step up on Mr. Hunley. All right, court calls CR 2344, State versus Christopher Lamar Hunley. We're set for pretrial today and the court has authorized Mr. Hunley to appear via Zoom today and he is appearing online. Mr. White, any announcement on pretrial, any contested pretrials?
Your Honor, I'm gonna be, I got some things I've got to look up and possibly try to get. 30 days. I think I'll have it.
For pretrial or for docket call?
For a pretrial.
Any objection from the state? Mr. White's requesting an additional pretrial on Mr. Hunley. All right, court sets Mr. Hunley then for pretrial on April 27th at 9 a.m. And are you gonna ask that your client be allowed to appear via Zoom on that day?
Most likely, yes. Some sort of resolution.
All right, so the court will authorize Mr. Hunley to appear via Zoom again for pretrial purposes unless you resolve the case. Mr. Hunley, if you resolve your case with the state, then you'll appear in person. If you do not, you'll appear via Zoom. Stay in contact with Mr. White and he'll give you the Zoom ID. You understand?
Yes, sir.
All right, you're free to go.
Thank you, sir.
Eight zero State versus Clifton, Nasir Gross. Mr. Gross, if you'll raise your right hand, I'm gonna place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you may put your hand down. Mr. Gross, your name is Clifton Nasir Gross, is that right? And Mr. Gross, are you a United States citizen? Do you read, write, and speak English? Ever been diagnosed with any type of mental condition? You're represented by your attorney, Mr. O.W. Lloyd. Are you pleased with his representation of you? Feel like you've had enough time to discuss your case with him, have all of your legal questions answered? Anything about the paperwork that you signed that you do not understand? And Mr. Lloyd, is your client competent today?
I am of that opinion, Your Honor.
And you've explained to him his legal and constitutional rights?
I have.
You've also discussed with him the advantages and disadvantages with a deferred adjudication plea?
I have.
Appears that the plea agreement in this case is that Mr. Gross is going to plead guilty to a second-degree felony offense of aggravated assault, causes serious bodily injury in exchange for the state's recommendation that a finding of guilt be deferred and that punishment be assessed at 4 years community supervision with a $1,500 fine and restitution in the amount of $6,327. Is that your understanding of the plea, Mr. Lloyd?
It is, Your Honor.
Yours as well, Mr. Gross? Mr. Gross, a second-degree felony offense carries a range of punishment of not less than 2 years or more than 20 years confinement in the Texas Department of Criminal Justice and a fine not to exceed $10,000. If the court approves this plea agreement today and the court later finds that you have violated the terms and conditions of your community supervision, The court could revoke your community supervision, bring you back to court. You would not have a jury trial at that time. You would have a hearing before the bench, and it would not be about whether or not you committed aggravated assault. It would be whether or not you violated the terms of your community supervision. You understand that? And the court, upon finding that, could assess your punishment anywhere within that 2-year to 20-year range. You understand that? So you understand the risk associated with a deferred plea? All right, Mr. Gross, I'm going to ask you at this time, how do you plead to that offense? And Mr. Gross, are you pleading guilty to that offense because you are guilty of committing that offense for no other reason? Because you're guilty? Has anyone threatened you, forced you, or pressured you to make you feel like you had to plead guilty? The court will accept the defendant's plea of guilt. Mr. Lloyd, is there any objection to the stipulation of evidence?
No objection, state number one, Your Honor.
States one's admitted into evidence, and the court takes judicial notice of the defendant's judicial confession. Is there anything further from the state, and specifically with regards to victim compliance?
Yes, Your Honor, there's a victim impact statement that's been presented on this case. We would ask you to have to move that.
We have no objection.
Thank you, Mr. Lloyd. I'm afraid we have the same issue with the admonishments in this one. There's just. Sure. All right, based on the court's review of the evidence, I find that there is sufficient evidence to convict Mr. Gross of this offense. However, the court will follow the plea agreement that Mr. Gross has reached with the state. The court hereby places Mr. Gross on deferred community supervision for 4 years, assesses a $1,500 fine, restitution in the amount of $6,327, orders him to pay $85 reimbursement fee. Mr. Gross, how old are you? 21. Have you ever been on felony probation before? Pretrial? And has that case been resolved?
No, Your Honor.
Is there a chance that he's going to get revoked in that case because of this one?
No, sir. They were aware that this was pending as well.
What's the, if you know, what's the charge and level in that case? Mr. Gross, you're awful young to have 2 20-year sentences hanging over your head. Does that concern you at all? Does that concern you at all? I mean, you've got, for the next 4 years, you're gonna have the government in your life. You realize that, right? If you don't know what the government is, you're looking at him. I'm the government. Your probation officer is gonna be the government. What that means is, if you don't take care of your business and do everything that you're supposed to do in these conditions, if you smoke weed, you drink beer, you go to a casino, you do anything that violates any of these things, you're going to be back in here and you're going to be looking at 2 to 20 years in prison.
Discuss in the way service.
Yeah, you have 4 years before you do that, but I just want to make sure that you understand the seriousness of these conditions. You need to make friends with your probation officer. You need to be that person when you walk in and sit down, they take you at your word and they know that you're working hard to do what's right and comply. You don't want them filing a motion to revoke, bringing you back. Because if you don't do your probation, you don't pay your fees, you don't maintain a job and do these things, then you're going to find yourself in prison. And that's not good for you. It's not good for me. It's not good for this state. Not good for your family. Okay? All right, Mr. Gross, you're hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of your sentence. I'm gonna have you step forward here to be fingerprinted with my bailiff. After that, then see Ms. Burns and she'll give you additional information.
Thank you, Your Honor.
Thank you, Mr. Lloyd. Appreciate your patience today. Yes, sir. Thank you. Ms. Heisel, can I give this back to you? I think you'll need to sign that. That goes to his paperwork right there. I think you'll need to sign that as well. Mr. Adams, are you ready? Jessica Sotelo, CR 2410. All right, Ms. Sotelo is set for pretrial today. Are there any contested pretrials?
No contested pretrial, Your Honor. To my knowledge, I've received all the discovery from the DA's office. I have a plea offer from them, but I would like to have some additional time to send to see things my way. In that regard, so I'm asking for a reset to the 27th. That's
All right, court will set Ms. Sotelo for docket call on April 27th at 9 a.m. Ms. Sotelo, once you sign your notice of setting and receive the yellow copy, have you met with the pretrial release department? You need to come over, have a seat, and Ms. Burns will be with you in just a moment. There's some additional paperwork that will stay where you're at, because he's going to stay where you're at. He's going to bring this notice to you. Once you sign that and get that, and come over here and have a seat, and she'll be with you. And then once you're through with her, you can go. All right, Mr. Adams, let's see, Mr. Kimmerling. We verified that he is in custody in Wood County.
That's correct, Your Honor.
Do we know what he's being held on?
No, Your Honor, I found out.
You found out this morning that he's in Wood County?
Yes, sir.
I show that he has an SOP already in this case, so since he is in custody though, let's just go ahead and set him again. Let's set him for that same April 27th for docket call and custody status. All right, Mr. Steele. Ms. Taberham, is Mr. Ashmore going to log back in on Zoom? If you're there. Anybody even knows that phone number? All right, the court finds that there is sufficient evidence to convict Ms. Marshall of this offense. Court hereby convicts her of attempt to commit hindering apprehension or prosecution of a known felon. State jail felony, the court will order and allow the prosecution under section 1244 subsection A. Court assesses her punishment at 1 day confinement in the Van Zandt County Jail. The court gives Ms. Marshall 1 day credit for time served on this case towards her incarceration. Court assesses a $2,000 fine, $290 court costs, and orders her to pay reimbursement fees of $35. Ms. Marshall, are you going to pay off all of your fines and court costs today, or when do you anticipate it to be paid off? Okay, so you know that you have to go down and meet with the court compliance officer to set up a payment plan, okay? Make sure you do that. If you don't, the court's gonna have to issue a warrant. We don't want to issue warrants for money. It's no good for anybody. You had one before? All right, Ms. Marshall, you hereby remanded to the custody of the Van Zandt County Sheriff so you can carry out the terms and conditions of your sentence. I'm gonna have you step forward to be fingerprinted by the bailiff. After that, then go report to the compliance officer down the hall to the left, Ms. Bonnie LaPrade. She'll set you up on a plan. Stormy McCoy. Are you Stormy Ray McCoy? All right, Ms. McCoy, if you'll raise your right hand, I'm gonna place you under oath. Ms. McCoy, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, ma'am, you may put your hand down. Ms. McCoy, are you a United States citizen? Do you read, write, and speak English? And have you ever been diagnosed with any type of mental condition? In this case, you are represented by your attorney, Mr. Kyle Still. Are you pleased with his representation of you? You have to say yes or no out loud. She's got to take it down. Okay, head nod does it. Okay. Do you feel like you've had enough time to talk with him about your case and have all of your legal questions answered? Anything about the paperwork that you do not understand? Mr. Still, do you believe your client to be competent today? And you've explained to her her legal and constitutional rights? And also the advantages and disadvantages of a deferred plea?
Yes, Your Honor.
Right. It appears that Ms. McCoy was originally charged with a state jail felony offense of theft, $1,500 to $30,000, but the plea agreement between the defendant and the state is to a lesser Class A misdemeanor offense of theft, $750 to $2,500, with the recommendation being deferred community supervision for a period of 12 months with a $1,000 fine, $270 court cost, and $35 reimbursement fee. Is that the plea agreement?
That's correct, Your Honor.
That's your understanding, Ms. McCoy? All right, Ms. McCoy, the range of punishment for a Class A misdemeanor is confinement in the county jail not to exceed 365 days or a fine to exceed $4,000. Do you understand that full range of punishment? If the court approves this plea agreement today and places you on community supervision and you subsequently violate that, the court could, upon making a finding after a hearing that you violated, the court could revoke your community supervision and put you in jail up to 1 year. And you understand that? All right, so Ms. McCoy, I'll ask you at this time, how do you plead to theft of property greater than or equal to $750 but less than $2,500? And Ms. McCoy, are you pleading guilty because you are guilty of that offense? Has anyone threatened you, forced you, or pressured you to plead guilty? The court accepts Ms. McCoy's plea of guilt. Mr. Steele, any objection to states one?
No, Your Honor.
States one is admitted into evidence and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor. Just note that we believe Ms. McCoy made some decisions to place her.
Thank you, Mr. McGuire. From the defense?
Mr. Pleasant.
I guess I have a question about this. There's nothing. There's nothing in the evidence that supports the finding of guilt or any kind of culpability on this McCoy's part. You have you have anything additional than this?
That's all we have.
I mean, because this says that she was driving.
She was driving the motor vehicle, the trailer was stolen. She stole property, the trailer. That's basically the allegations.
And the report says that the officers conclude that Justin Gilmer unlawfully appropriated the trailer.
Yes, sir. We believe that this is Gilmer's primary actor. We believe that this McCoy, in driving the vehicle, pulling the stolen trailer, appropriated all those things that
and that she knew that the trailer was stolen?
That is our, sorry. I suppose that last question we need the jury. If she was the driver. Then there are also assisting officer reports. I think there's some indication she had.
Ms. McCoy, I'm going to ask you a question in just a minute, and it's not going to affect whether I approve your plea or deny. Well, it could affect if I deny your plea, but I'm going to ask you, and you're under oath, and if you don't feel like answering, you can talk with Mr. Steele, but did you know the trailer was stolen? So what, is that a yes or a no? All right, so what I'm going to do right now, I've got her judicial confession, but I don't have anything that supports the plea over and above that. So let me let you all get together. I just don't know if I can legally accept it if I don't believe the evidence supports it. If there's another offense report where they interrogated her and she says, yes, I knew, or she was deceptive, or there was circumstantial evidence that suggested that she knew. She's telling me that she didn't know that it was stolen. She told me that she's guilty, but then she told me that she didn't know it was stolen.
Sure, Judge, I in line with this, I guess I'd ask for a reset, because I don't think there's something we can figure out in the next 2 minutes.
I think we can try. I mean, we still have a couple of you other clients we're waiting on anyway. So
Okay.
why don't you go ahead and talk with the state and Ms. McCoy, and we'll recall her case and yes, absolutely. Okay. You bring Mr. Ashmore's gone again. Austin, is Casey with you? Good morning, Mr. Ashmore. Sorry for we had some technical difficulties. So Ms. Abraham's watching right now. Ms. Abraham, I found Mr. Ashmore. He's on my screen. I've captured him.
Yeah, and I'm sorry, Judge, we had the same problem. My Zoom dropping off. And so forgive me for that.
No problem. All right, Ms. Fowler. The CR 2333 and 334, State versus Grace and Fowler. She's making her way to the center podium. We're set for a docket call today, Mr. Ashmore.
Yes, Judge, we don't have any contested pretrial motions, as you know. We're continuing to work with the state and our client to see if we can resolve this short of trial. We just asked the court for a reset. No really other announcements than that.
You received an offer in the case?
Yes, Judge, the offer is 40. And that's a bitter pill for any client to swallow, especially a grandmother. So we're trying to see if we can move the needle on that and come to something that all sides can live with.
All right, give me just one moment here. This is our first docket call setting today, Ms. Heisel. Do you have any objection to Mr. Ashmore's request for an additional docket call? All right, Ms. Fowler, the court's going to reset and give you an additional court date on April. Are you available on April 27th, Mr. Ashmore?
I'm pulling that up just one. I think I'm there, but let me double check, Your Honor.
He's on right now. That's a judge. Standing right next to him.
Yes, Judge, I'll be there.
All right, so Ms. Fowler, the court's going to order you back on April 27th for docket call. Fill out a notice of setting. Once I have you sign this, well, I'm going to get you a yellow copy. After that, I need you to report to pretrial release. There's conditions of pretrial release that you're going to have to sign today. They're going to be attached to your bail in this case. You're going to have to report, pay money towards your court-appointed attorney, BUA, things of that nature, okay? And Ms. Burns is going to have that paperwork for you. After you meet with her, you'll be free to go, okay? Bailiff, if you'll assist me, you'll just hand that to her and here's a pen. Okay, so Ms. Fowler, you're going to sign there on the X and then the bailiff will give you the yellow copy and then come over here and have a seat. Ms. Burns will be with you shortly. I'm gonna have Ms. Fowler for you on pretrial conditions. Send this to tell you. I did, okay. I try to check that off, Karen. I'm not always sure what I do, so. All right, let's see here.
Judge, if we could recall this complaint.
Just one moment.
We have
Robert Yates. Robert Yates.
I need to report on Mr. Yates. He's been hospitalized. We've been in contact with him this morning. And we're trying to get documentation to the district attorney and the court from the clients. But so far haven't been able to do that. I thought I was just going to be making a trial announcement today and he'd be present, but he has requested some time in light of this. And, you know, we're assuming that this is a meritorious emergency because literally called from a hospital bed.
Okay, court will take a judgment nisi under advisement until 5 p.m. tomorrow. That should give you and your office some time for his family to submit that necessary documentation. So court will take that under advisement until 5 p.m. on Wednesday, March 24th.
Thank you very much, Your Honor.
And what we'll do is we'll go ahead and set him for docket call on 4/27. What about Matthew Gould? Is Matthew Gould here? CR 2389. He's going to make his way to the center podium. All right, this is CR 2389, State versus Matthew John Gould, and we are set for pretrial. Are there any contested pretrial motions today, Mr. Ashmore?
There aren't, Your Honor. We are still working through the discovery and we do not yet have an offer. So we're just asking the court for a reset.
Any objection from state? All right, court sets an additional pretrial on April 27th at 9 a.m. Gould, I'm gonna have you sign a notice of setting here for that new date. Once you sign that and get that yellow copy, Mr. Gould, then I'm gonna have you come over here and have a seat and meet with the pretrial release department. They've got some paperwork for you.
Okay.
There's gonna be conditions of pretrial release that I'm gonna attach to your bail today. All right, Mr. Ashmore, I believe that's all you have. Is that correct?
Yes, sir, till 1:30, and I appreciate the court allowing me to Zoom today. We had some conflicts with the spring break and the ice storm and everything getting pushed into this month, so I appreciate that very much, Your Honor.
Will you be zooming to the jail today or will you be in person?
Unfortunately, I'll probably be Zooming. It'd be my preference to be there, but I don't, like I
Okay.
said, Brad and I are scrambling to cover stuff this week, and if I can be there, I'll be there.
All right, sounds good. Let's see you soon.
Thank you. May I be excused, Judge?
Yes. Is
Thanks.
Carl Clump here? Carl Clump? All right, Mr. Clump is not here. Leslie Gibson? All right, Ms. Gibson, if you'll come to the center. This is CR 2249. Ms. Gibson, I called your case at 9 a.m. and you were not here. Yeah, Mr. Stevens was here, and so Mr. Stevens had to go to another court and he's not gonna be back till this afternoon. So I'm gonna order you to come back today at 3 o'clock and come to the courtroom. Don't go to the jail. Just come to the courtroom at 3 o'clock. Okay? So you're free to go until then, be back here at 3. If you're not back here at 3, you know what's gonna happen, right? Okay. Leonard Williams. CR 2372. Mr. Williams, same case for you as that previous defendant. I called your name at 9 a.m. and you were not here. Your attorney was here, said he hadn't heard from you.
No, I talked to my attorney. I had to call my-
Actually, no, I'm sorry, you're right. He did. He said he talked to you yesterday.
My attorney when I got from the hospital yesterday, and he told me that we was in person. I thought it was
Zoom.
Zoom,
Mhm.
and I didn't know what time. I got to ask somebody for writing it down. Get in no type of trouble.
Understand. Unfortunately, Mr. Stevens had to attend court in another county, but he'll be back here at 3 p.m. So unfortunately, I'm going to order you to stay around town and come back to this courtroom at 3 p.m.
Yes, sir.
Okay?
Yes, sir.
All right,
I
so,
apologize.
well, I'm just, yeah, you're here. That's the main thing.
Yes, sir.
All right. We'll see you at 3. Mr. Steele, do we have any? Okay, so yes, Mr. Woodwhack on Mrs. McCoy, if y'all want to approach. All right, Ms. McCoy, we got halfway, well, we got probably about 3/4 of the way through your plea. And so I had a question about it. The attorneys are gonna, I don't know if your client, if you've already spoken with your client, Mr. Steele, or not, but he may have additional information for you. What I'm gonna do is, rather than accept your plea today, I'm gonna reset your case for a couple of weeks. I'm gonna give you a new date. But after we're done here today, I want you to report to pretrial release. And I want you to discuss with them. I show that you have some financial delinquencies that you owe the pretrial release department. Those are the notes that I have. Whether you do or you don't, I don't know, but I want you to report to them. And if you do, I want you to be in good standing. And then I think there's a good chance when you come back in a few weeks, your case may be dismissed. Okay? You understand? Okay. So let's see here. Mr. Steele, I had you coming back on, who's your other client? I already reset you on someone else? No, we were waiting on the other two. We're waiting on the other two.
Mr. Gray and Mr. Watkins are being judged.
Okay, okay. So what about, you got your calendar with you? You know when you're available?
April 27th is fine, if that's okay with you. Judge.
That's fine with me. All right, so Miss McCoy, court's going to order you back on April 10th at 9 a.m. If you meet with probation department today and you resolve all of your issues, then the attorneys may contact the court. And if they dismiss your case, then they'll give you notice and you won't have to be here. But until that happens, then you're going to report back on the 27th at 9 a.m. Okay, so Mr. Steele, I'm gonna have you fill this out real quick. Give her the yellow copy. Once you get the yellow copy, come back here and meet with Ms. Burns.
Judge, you said the 10th and the 27th.
I'm sorry. April 27th. I got 10 cases.
Okay.
April 27th at 9 a.m. April 27th, not the 10th. Okay. Yeah, I can. Here in person, unless Mr. Steele gives you a motion to dismiss that's been signed by the court. Okay.
on the docket 21st. We signed it.
21st of this month, like 2 days ago.
Yes, sir.
All right, Mr. Steele, you were asking the court to reset Mr. Watkins for an additional docket call. Is that correct?
Yes, sir.
All right, court's going to reset Mr. Watkins for docket call on April. Are you available on April 27th?
Yes, sir. We said, yes.
All right, Mr. Watkins, the court's going to find that your bail in this case is insufficient based on your admittance to the use of a controlled substance while on pretrial release. The court's going to order you into custody at this time.
My father had a stroke. I don't know what to take about that.
Understand. Understand. Yes, sir. That's fine. Go to that podium right there, so you'll be on the microphone. All right, this is cause number CR 17147, State versus James Cody Gray. Mr. Steele, you requested an additional setting on the motion to revoke. Is that correct?
Yes, Your Honor.
All right, we're going to set Mr. Gray for a hearing on his motion to revoke. Actually, I'll tell you what we're going to do. We're going to set him for a contested hearing on April 29th. Meaning that if y'all don't have a resolution, then we'll just hear it and the court will make a decision on April 29th. That'd be at 9 a.m. You have any conflicts that day?
Yeah,
We can do it next week.
Judge, I have to be in Cook County on the morning of April 29th, which is probably the opposite of the universe for me.
Can you be here in the afternoon?
Yeah, I could do 1:30, is that,
1:30 is fine.
yeah, I can do 1:30.
All right, we'll set him at 4:29 at 1:30. I think I've already set somebody for 1:30 anyway, so. All right, Mr. Gray, this is what we're gonna do. You're currently on community supervision, aren't you? All right, so what I'm gonna do is I'm gonna release you to the custody of Officer Gain here. You're gonna go with him and stay with him until you give a specimen. Okay? And if that's positive, then I want you to report to the Van Zandt County Justice Center at 1:30. Okay? If it's negative, you'll be free to go. If it's positive, you're gonna report out there. All right? So if you'll just text me or whatever and let me know. Okay? All right, I believe that's going to conclude the morning docket where we're going to recall Miss Leslie Gibson at 3. We're going to recall Mr. Leonard Williams at 3. Those gentlemen, two individuals will be here, one man, one woman at 3 o'clock. And I believe Beta Ragsdale is going out. Yes, thank you, Mr. Steele. All right, so Mr. Steele, I don't need to see you then at all. You got some on the afternoon docket, right? Okay,
And given the fact that 30 minutes, I may not get on until about 2 o'clock.
okay.
I think.